Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening, everyone, and welcome to a new episode of SIPA podcast, the first intellectual property podcast in the Arab world, Middle East, and MENA region. And it's one of the activities of the Scientific Intellectual Property Association, SIPA. Today, again, we have a special episode with a very special guest. He's one of the prominent figures in the intellectual property field worldwide, especially in US. He is a global chairman. He is a US patent attorney, and he is attorney at law also. He has a university degree in electrical engineering, as well as a doctorate degree in law. And he has a very wide experience over 36 years in intellectual property regarding litigation, prosecution, counseling, licensing, and also providing strategic advice for intellectual property portfolios worldwide. He established his own law firm. It's a very global law firm that has offices in US, UAE, France, Switzerland, Japan, China, Singapore, and still counting. He's also the founder and president of CompU, which is a non-profit organization that provides free computers and computer education to children in underserved communities. He has a wide range of expertise related to AI and AI issues related to intellectual property. And he served as a general reporter to AI PPI, through which he has some kind of resolution related to AI worldwide. He's also the editor and co-author of one interesting book entitled AI and Patents. He also chairs the AI task force with the American Intellectual Property Law Association, and he is a frequent speaker for AI-related matters. Let us welcome Mr. John Osha.
Thank you so much. It's really a pleasure and an honor to be here. I look forward to our discussion.
It's our pleasure to host you with us today. And I know that we want to make use of every minute from your time. I know your time is very valuable and we enjoy listening to you. We always meet you during conferences and we enjoy your speech related to AI and IP in general. And you know that today we will talk about a very debatable area related to AI tools and intellectual property violations that happening because of the using AI tools in creating intellectual property works, whether it's patents or trademark or copyright, etc. First of all, what would you like people to call you? Like John or Jonathan?
Oh, John is perfect. Yes.
John is perfect.
Yes. Thank you.
Okay. Can you, in brief notes, inform the audience who is John Osha and how you started your long journey over 36 years in IP field?
Well, yes. So I'm on my third career. So it's a bit of a funny story. I'm the product of two failed careers. My first attempt at a career was in music. I was an opera singer, and I found that I was good but not great. So I was never going to be, really successful. So I decided to try engineering, and I went to Cornell University for electrical engineering. And again, I found I was good but maybe not great. And well, what else can I try? And so I went to law school. I got into intellectual property, and I found something that really fit for me because it's such a unique field of being in depth in the technology, but also in the policy space and in the human interest space. All of this kind of wrapped together is really, I feel very fortunate to be in the intellectual property field.
Yes, that's very interesting. We always hear about how AI is infringing the copyright of authors or creators or inventors. From your experience, how AI tools infringe other writers or other creators Like we have text generated works, we have image generators, we have different things. So how they infringe the already protected works?
Yeah. Well, maybe before I answer that question, because that's a key question, it's helpful to back up a little bit and talk about AI in general, because AI is all around us, first of all, and there's so many different types that when we talk about an AI tool infringing or not infringing, it's important to define, I think, the scope of what we're talking about, right? So for example, we have AI tools that make decisions, right? For example, an AI-enabled tool may decide to apply the brakes in your car when you come to an intersection, if you forget to do so. And that's the decision-making type of AI. You might have recommending type AI, where, for example, if you put in a search on Amazon or any online platform, and it's going to give you the top few choices based on a bunch of stuff that it has learned about you and your past purchase history, right? And then we have the so-called generative AI, which can produce songs that sound like a particular person, or any sort of written text, fake videos, real videos, whatever the case may be. And each of those scenarios raises a different set of policy concerns for us in intellectual property. And there's subsets of those, particularly when we get to talking about patents. So to try to answer your question, if we limit the scope of that question to generative AI, then we have a question about whether the use of copyrighted works to train these machine learning systems is an infringement of the underlying copyright in that work. And the answer to that is we don't know, right?
Yeah.
We don't know yet. There are numerous lawsuits that are currently pending in the United States, one significant one in the UK I'm aware of, that are going to try to answer that question. Part of the problem we're going to have is that the underlying law is not harmonized country to country. For example, in the United States, there's something called fair use. And so certain uses of people's copyrighted works without their permission is considered fair. On the other hand, in Europe, generally, that fair use concept doesn't exist. So even on the same set of facts, we may get different answers in different jurisdictions. So it's not a question that we can answer definitively yes yet, right?
Yes. I know that you have wide and range experience in all types of IP, patents, and you have also experience in trademark and copyright, but I know you are more focused on patent. So from your experience, which type of IP is mostly being infringed or violated by AI tools? Is it patents or copyright or trade secrets or?
Well, difficult question. I mean, I would say in terms of just volume, it's going to be copyright.
Copyright.
And where you see people's rights impacted most directly. And again, there's a spectrum. I'm not trying to be evasive, but there's no black and white answers to these questions. But consider a very large system, a gigantic system like ChatGPT-4, that's been trained on trillions and trillions of pieces of information. It can do lots of different things. It wasn't created necessarily to create a particular type of work.
Yes.
On the other hand, there are AI systems, including online available systems today, that, for example, can produce music in the style or sound of a particular musician. So you can go and say, please create a new melody that sounds like Taylor Swift or like The Weeknd, which actually happened.
Yes.
And it will do that. Well, that system is really designed to create problematic works, right? Now, whether they're technically infringements or not is another issue. But they're really designed to create those types of problematic works, whereas some other systems aren't. So there's a big spectrum there of how those systems are intended and designed to be used, and then also how they are used by a particular user that engages with that platform.
Yes, so if we have a work generated by AI tool, can we consider it as original work, or it's a derivative work from original one?
Yeah, and also an interesting question. So in one sense, it's always going to be a derivative, right? Because in some way there was access. But when you get to a certain volume and you get a certain degree of change and injection of new stuff, if you will, it likely ceases to be a derivative work, right? So again, there's a very large spectrum of what can come out the other end and how different it may be. If you look at the Getty Images cases that are currently pending in the UK and in the US, the output of the system partially but recognizably recreated the Getty Images watermark. And that would tend to make one think that a Getty Images work was used, one or more was used to help create that image, right?
Yes. So there is 1 million question that everyone is asking us during the conferences, during the discussions about, if I use AI tool to create a work, whether it's a patent or a copyright or whatever, after the work is created, who owns the IP rights? Is it the developer company who created this tool, or the user, or nobody? This is one side. It's a double-sided question, actually. On the other side, if there is some kind of violation, who is liable for this violation? This is I know that it's a very complicated question that we are always discussing in conferences and workshops, and it will be very great to hear your insights related to this point.
Well, again, I can't give you a definitive answer. I can tell you what I think.
Yes.
For what that's worth. So copyright is intended at a very high level to be a way of encouraging human creativity, right? If you go back some hundreds of years, that's why we give copyright, which is literally a right against copying. We want to encourage artists and musicians and authors. We want to encourage human creativity. So over the course of time, various tools have evolved that have aided human creativity. The ballpoint pen, where you don't have to put the pen in ink, right? Printing machines, certainly word processors, more recently, grammar checking tools, right? And then along comes artificial intelligence. Now, is that just another tool in this spectrum of tools, or is it something that's really entirely different? So I would ask you, for example, if I write a creative work and at the end, I feed that into an AI system and I say, please check my grammar and my spelling, make sure it's okay. Is that still my creative work at the end? I think most people would say yes, right? Yeah, sure, the computer did some editing, but
yes.
Now, what if I had that same creative story in my head, but instead of writing it out, I wrote it out in bullet points, just bullet points. Point 1, this happens. Point 2, this happens. Point 3. I create the storyline. I create the intrigue. I create all the meat, but I didn't put all the words, the ands, the these, the verbs. Yes. And I give that outline to an AI system. And I say, hey, fill this out. Is that still my creative work?
I don't think.
See?
Yes.
So you'll get different answers on that, yes, right? And
yes.
Then you can go further, right? And of course, at some point you get, you put an input prompt that says, write me a story about a guy and his dog. and it writes you a story. Well, clearly that's not human creativity, okay?
Yes.
So you've got these endpoints that are very clear, and then you have this spectrum in the middle that's not. And that's going to be where we're going to have to develop some law, because we just don't know right now. Right? And the position of the U.S. Copyright Office, as they stated in February of this year, so there's a new statement, is that if an output is created by the machine, there is no amount of creativity in the input that's going to create a copyrightable output. That nobody owns that. It's not protectable. You can get a copyright in the input you give to it, of course, which you already have as soon as it's fixed in a tangible medium, but you don't ever get a copyright in the output. I disagree with that. I think there's a point where the human can inject enough creativity into that system that the machine is just a tool and it's reflecting your creativity. But we haven't seen a case that says that yet. So I'm just telling you what I think the answer should be.
Okay. Talking about creativity will take us to another point. It's my concern. One of my concerns related to, this is one, I think it's one side effect or bad effect of using AI, that in some way or another, it kills the creativity inside the humans in general, especially in the education sector.
Yes.
Before, when we were studying, like in the school or in universities, when we are assigned to do write some kind of essay or article or something, we have to go to the library, open the books, and gather information from here and there, then write it in our own way. I remember when I had my master's degree in Egypt, it was in English literature. We spent around 3 or 4 years gathering. We have to draft one thesis and defend it in one viva, and we have to revise it with the supervisor about the plagiarism and copyright and all. I think you're already aware of that. Yeah. And before the viva, I remember that one of our professors there in Egypt, they asked us to put the whole thesis in one system called Grammarly.com. It's a US website. Yes. That will detect any kind of plagiarism or copyright violation or IP violation. So now in this age, how universities can deal with this kind of issue? Now, if I am a postgraduate student preparing my master's degree or PhD dissertation or something, I can use any AI tool. And it's not wrong to use it, but how universities can deal with, is it original that I will consider it as a tool to help me, or I will make it do everything for me? And how I can discuss with the student about his thesis, about his point, about his dissertation, how we can figure out this kind of concern, especially that, as I told you, it can kill the creativity element in the human being.
Yeah, this concerns me a lot too, so I agree with you.
Yes.
I think at the end of the day, the educational organizations are going to have to set policies. There are AI tools out there already, like advanced versions of Grammarly, that can detect whether something is completely AI generated or not. And when it comes to advanced degrees, there's going to be, I think, heightened emphasis on the oral defense, because the AI might be able to write you a nice master's thesis, but if you can't defend it, then you probably don't know what's going on. And in that case, it would be very much like if you just paid somebody else to write it for you.
Exactly, yes.
So I'm not so concerned about being able to deal with those issues, but I am concerned about the creativity issue. And it's not a new thing. When I went to law school to research a case, I had to go to the library. And I had to look through these dusty indices and then go look at books and read,
exactly, yes.
Take notes. Yeah. And today the law students can put in a query in a system, and I mean, even before AI, and get a list. Yeah. I think something's lost there in not having to go through that boring intellectual process.
Yeah.
But at the same time, things are much more efficient. So it's a balance. So like all other tools, we need to be careful how they're applied. We need to set clear criteria. And that's one thing that governments are trying to do around the world, is to set criteria for use of AI. When can it be used? What are the safety implications of using AI? How do we prevent bias? A lot of these legitimate concerns completely outside of the IP arena that governments are trying to deal with, because it is a game changer.
Yes, I think this relates to what we call AI ethics.
Yes.
Now there is a new trend called AI ethics, or ethical AI, that people thinking about how to make AI tool respect copyright and IP rights. This is possible. It can be done. Like, I can design, like if I am a developer company, I will design AI tool to be used for different things. Can I use some kind of ethics that, regarding universities, for example, if I ask him to give me some article or some essay or something, can this AI tool give me the citations, the quotations, the references that has been used in order to give me this output? Is it possible?
It's absolutely possible from a technical standpoint. Yes.
Yes. Like if it takes information from a short story written by Charles Dickens or someone in the past, can this give some kind of citation to this work?
Yes, absolutely. If you train the system to give the output in that format, you can. And there are also systems that can do that in the other direction, that can identify the percentage, the portion of particular inputs into the outputs. And those are kind of, plagiarism checkers, if you will.
Yes.
But the ethics issue of AI so far has been more focused on kind of public welfare and safety. If you look at, for example, how it's been addressed in Europe, which Europe may be the furthest along, I think. It's like a pyramid where the highest obligations are on the systems that have the highest potential for impacting people in a negative way. So, for example, facial recognition systems, or systems that decide to allow or deny credit. These sorts of things that would have strong impact if done unfairly, if biased, have a higher obligation of transparency and reporting and such versus other types of systems. So we'll probably see that type of regulatory approach in most places, ultimately. But that, again, that's away from IP. I didn't answer your question, your two-part question on liability. I'm sorry, I only asked you the first half. Do you want to answer the second half?
Yes, of course. Yes.
Yeah. So, because that's another interesting question, and I'm going to endeavor to not give you any clear answers today. Okay. So this will also follow in that respect. But when it comes to liability for an output generated by a Gen AI system, and we don't have many cases, but there is a substantial amount of law out there over what contributory infringement means. Right? So if, generally speaking, contributory infringement, whether it's patents, trademarks, or copyrights, involves a party that knowingly contributes to or induces, the slight difference in those two, but we'll wrap them together for present discussion purposes, somehow encourages or instructs another person to create that infringement. Right? So I expect that this is where the law will go on creation of infringing works using generative AI systems. So if you have a user that's using a very broad general purpose system, and that user sets out to create something that's an infringing work and does so, then probably the liability lies with that person, not the tool on which the work was made. On the other hand, is my earlier example of a music system that the whole purpose is to copy somebody's music, then probably there's a contributory or secondary liability on the part of the person that set up that system.
Exactly.
Right?
Yes.
Particularly if they're doing it for commercial purposes. And I went on just such a system, and I created music in the style of, I think I chose Billy Joel because I like Billy Joel. And I got this song that kind of sounded like Billy Joel. And so I'm thinking about who owns this, because I came up with a little melody, a one-line melody, and put it in the system and said, please make this sound like Billy Joel. So I own the copyright in that melody. All the Billy Joel stuff, Billy Joel should own, right? But at the end, the system asked me if I wanted to buy a license from the platform in what I had just created, which would imply that the platform owns it. And I'd say the only person who definitely doesn't own it is the platform, right?
Yes, exactly.
But they're doing it for a commercial purpose. So
yeah, I will tell you my opinion.
Yes.
My personal opinion. I consider the user is the owner of the rights, as well as he will be liable also for the violation if it is there.
Mm-hmm.
I think it's because if I'm the user, I am the one who is giving the orders to the machine itself or to the tool to give me the product. There is some kind of analogy we can do, like it's like a weapon. Like I will make a knife or a gun. The gun is there, the knife is there, but the use is different. I can use it in normal housework, or I can use it to kill someone.
Yeah.
So the user has the liability for the violations, and he should have also the rights if he use it to do some kind of work. This is my own opinion. I don't know what will happen in the future. And your company, Osha BWB International, has offices in different countries, in different regions also. And I know that you have attended a lot of conferences and you have visited a lot of countries. So from your experience, how countries are dealing with AI issues? And is there very big gap between these countries?
Yes, there's a lot of gaps.
Yeah.
So Europe in general has approached the issue from a almost public safety standpoint, public welfare standpoint, democratization of digital online space, access to everyone, that type of approach, which is what we've seen in the EU AI Act and the EU Data Act. If you look at Japan, for example, Japan has been, at least on the IP side, way out in front, I think, in terms of some actions that they took very early on, recognizing that IoT and then AI was going to be a big thing, and having, I think, pretty clear systems in place for how to protect, at least on the patent side, AI systems. And China likewise has put guidelines in place that are relatively clear. So we're able to protect AI systems, again, on the patent side in China that we can't protect in the United States, for example. So you've seen these kind of administrative approaches in Japan and China. The kind of democratic large-scale overview picture approach being taken in Europe, and in the U.S. I think the offices, the Copyright Office, the Patent Office, are valiantly trying to put policy out there. But as you probably know, they don't get to decide. It's Congress or the courts, yes. And our Congress in the United States is kind of busy with other stuff at the moment. So I don't know when we're going to get to IP issues, but I hope we do sometime soon.
Do you think that the Middle East has reached some stage in dealing with these issues, AI issues? Especially that UAE, we have some laws are there and some centers also dealing with this AI in general, not only for IP. Yeah. So do you think that there is some kind of a stage we reach already?
I think here in the UAE, there's been an impressive amount of attention given to the issue. And
it was very early also.
Very early on,
yes,
yeah.
Yes.
And I've been really impressed with the level of understanding and the amount of attention given to the issue. So I'm very happy to see that and look forward to the further results of that work.
Yes. Now I will ask you a question from the creator side. If I'm a creator, a writer, an artist, or whatever, doing some kind of IP work, of course, you face some kind of fears coming from this side, that I'm a writer. I face myself some kind of issues with some writers who are afraid to do some kind of digital books. And they are saying that once we put it online, it will be taken as a copy and it will be shared in different sites, different websites, different countries, and some countries don't have the full litigation procedure to follow or to find out who is the infringer or who is the violator. So do you think that blockchain, or you mentioned something earlier about the watermarking, and do you think that blockchain and watermark can help in protecting this kind of works, on detecting the violation?
Well, digital watermarks certainly help.
Yes.
Absolutely.
Yeah.
Blockchain maybe depends on the application. But that is one of the tricky things about protecting AI systems. So again, we're talking about two different things. One is whether an author's work, say a photograph, was used to train a system that was then used to create some other work, right? And whether we can look backwards through that lens and see whether there was an infringing use of that work. And there already are systems that can help us do that, but certainly a digital watermark is going to be helpful, I think, in that respect.
Yes. Do you think that the current laws that we have in different countries can be evolved or upgraded or some way or another to face this kind of AI issues and AI tools and infringement related to IP, or we need new laws from the beginning?
That's a really interesting question, and is one of the questions that we considered at AIPPI. Is the current law sufficient to deal with this new technology, or is
I think when you are the general reporter with AIPPI, you propose some kind of 4 resolutions related to.
Yes, every year
you just give us a hint also.
But ultimately, the consensus so far has been that the existing base concepts of intellectual property protection, copyright, trademark, patents, trade secrets, are sufficient to deal with AI systems, but we will need development on exactly how they apply in different situations. And I tend to agree with that. The one possible area where something new might sneak out at the end would be protection of AI-generated works. Because there is this disconnect possibly between the human creator and the output of that work. And should all AI-generated works truly be public domain? Nobody owns them, nobody can protect them, or should there be some sort of mini copyright, some short-term sui generis kind of thing? And interestingly, the UK law has such a mini copyright, if you will, protection in it specifically for computer-generated works. It's actually relatively old, so it was in the UK law before all this AI stuff came out. And it hasn't really been used much, so we're kind of looking to see how that works
But I think in most countries, they don't consider the AI tool to be a creator.
Correct.
In most laws, especially in the Middle East, the creator should be a human being.
Yes.
So how we can change this?
Well, but I think that should always be the case, in my view. The machine is never the creator. Just like there was so much time wasted on this argument over whether AI can be an inventor on a patent.
And you know what the story of that was that happened there?
Yeah, I know. And the answer is very clear. No, that was never. The issue is, what is the human role using an AI machine in the invention process, right? Yeah. So exactly in parallel to that, when it comes to copyright, the question is not, is the AI tool a creator and should it have human rights and get copyrights? No, of course not. The question is, how much human creativity is necessary when filtered through an AI system for that human creator to deserve rights in the resultant outputting work? And that's the question that we don't have the answer to right now.
Yes. Talking from the legal legal point of view, that now how courts are dealing with this kind of issues. dealing with IP traditional issues is okay. We have the laws, we have the executive regulations, the judge can find a lot of things to use. But now, how can the courts deal with the issues related to IP and AI violations, especially that there is no clear-cut laws that the judge can look into? And as you said earlier, that there are different opinions. And we heard about some cases in US when some writers and creators went to the court to complain about against some kind of companies, developers, that these machines, AI tools, are infringing us. And the court decision was, no, they are not infringing, something like this. So from your experience, how the court deal with this ongoing issue?
Well, I think on the issue of use of copyrighted work as training data, we're going to see a bunch of decisions in the coming year because there's at least a dozen cases pending right now in federal court that are looking at this issue. We've had one decision so far, but it's a bit of an anomaly, so I'm not going to rest. The fact pattern was pretty specific. We're going to get those decisions from those federal courts. They're going to go to the appeals courts, and ultimately, I hope, we're going to get a decision to the Supreme Court. And we're either going to need to have that, or we're going to have some action from our Congress in the United States for there to be clarity, because nobody knows right now. It really is a conundrum, because on one hand, the companies legitimately want to develop AI as quickly as possible. We want that too, right? As the consumers, we want that technology to continue to develop. It's amazing today. It's going to be even more amazing tomorrow, right? On the other hand, if that development requires devouring the creative works of our musicians and our artists and our authors and destroying their careers, is that something that we want to allow to have happen? And it is absolutely devastating for artists and authors. You know, when you used to have to go hire them and pay them to create a work of a particular type, and now you can type in, you know, please create a work in the style of John Osha, you know, and boom, there it comes.
Do you think that this will discourage the creators to do some kind of new work and all? Some kind of discouragement will be there?
It will sure discourage them from putting them online.
Yes, exactly.
Yeah. And, you know, in terms of big picture, what I hope to see, I'm old enough to remember pre-digital music, right? And, you know, back when it was vinyl, right? And when we started having digital music, all of a sudden there were these services that you could download music from free. And people at the time legitimately, you know, I mean, really honestly argued that, well, that's not protectable by copyright. You know, it's just electrons. You know, if it's not printed in a record or on a cassette tape, so that's okay. That was Napster and stuff like that. And that was a real argument for a while, but ultimately it was decided that, well, no, that's just another way to represent music. It's still music and it's still protectable, right? And I think we're going to see ultimately a similar type of evolution of view. There's a lot of people right now that say, hey, everything's fair game for training purposes.
Yes.
In my view, that can't be the answer, right? Now, what is the answer? Well, how did we deal with music royalties, right? Because we had this issue of, okay, I own a restaurant and I want to play music in my restaurant. There's no way the transaction cost is so high. I can't go buy from all the different artists I want. I need some sort of clearinghouse, right? And that's what was created, these music collection societies where the musicians would assign their rights into these organizations. They might be nonprofits or for-profit, whatever, and then those organizations in turn license my restaurant and your hotel or whatever, and reduces the transaction costs. It may be that there's a solution like that. And I hope it would be voluntary, not mandatory, but voluntary, where creators could choose to put their digital works into this collection society that then people could buy access to inexpensively for training data. That royalty would then get distributed back out according to some formula, just like music.
Yes.
And that's a future I hope to see.
Yeah, related to this point, recently we see some kind of platforms like YouTube and Facebook and social media. They have some kind of technical thing that when you post something like a video or a musical something, they will detect.
Oh, yes.
The video will take some time, some kind of processing it there. They will detect their database if it is protected or not. And if it is protected, they will not allow you to post it. So my question is that why other websites cannot do the same thing? Like when I write a short story, I put it there. Before posting or accepting it, they can detect, is it original work related to me or it's infringing other people? Is it possible to do that?
I think that's difficult.
Yes.
To have some sort of electronic determination of whether it's
talk about AI ethics and all.
Yeah.
Respecting other people's rights.
But again, whether you have a legitimate right to post it, that's something that you would think a system could be trained to do. I don't know how you would get back to the underlying factual question of whether you own those rights or not. I think that's
very difficult.
That's a bit difficult.
Yeah. Have you recently worked in any case related to AI tools infringing IP rights in any country?
Absolutely.
Yes.
So again, to be clear, the tool infringing or the output infringing?
Yeah, it's two different things.
They're two different things.
Yes.
Right.
Yes. Okay.
So I've worked on both.
Yes.
Yeah. So the tool infringing is typically a patent question, right? And the issue there is one of how do you know? So we patent a system that uses AI in some way, and somebody else is in the market with a tool that functionally does the same thing. The problem is it's very, very difficult to know how that system was trained. So whether their system is actually doing what our patent claim says.
Yeah.
Right? Now in the US, we can overcome that because we have discovery. In other jurisdictions, that's much more difficult, more fraud, right?
Yeah.
The output issue on a copyright standpoint is in my view a little bit more clear, but we're going to have to wait and see what some of these cases say, particularly like the Getty Images case we talked about earlier. But I think there's situations where if you can show that your photograph was used as part of a training data set, and there's a photograph that looks a whole lot like it that came out the other end, that would otherwise be an infringement as a derivative work had it not been run through this system. How does it become not a derivative work just because it went through this system, right? So we have encountered these types of situations.
Yes.
There's also there's a huge issue around data licensing. You know, we've talked a lot about the unauthorized use of copyrighted works. There's also the use of data, and data generally is not subject to copyright, but it can be immensely valuable. And so there's a whole new field of intellectual property that we're dealing with now, which is these cross-licensing of these huge data sets.
Yes.
And who owns what? So like a lot of our, to the IP transaction people out there who might hear this, you need to look at all your agreements anew. Because we discovered, for example, that some of our standard terms and conditions didn't anticipate all the issues that are actually coming up, right?
Yes.
So just to give you an example, if we have time,
Yeah.
I have a client that has an AI system that labels photographs. So you can upload, you buy a membership, you upload pictures, and it will label stuff, table, coffee mug, microphone, right?
Yes, yes,
yes. And then it will send those pictures back with the labels on them. And people like that for whatever reason. Maybe they're trying to sell a house and whatever. But so it's this service. And the terms and conditions explicitly say that the user represents that they have the copyright ownership of whatever photographs they're sending in, and they own the result too, right? So the platform doesn't own it. But the platform does get a little smarter each time it does this,
Yes,
right?
yes.
Because if it labels this a sofa, and it's, the end user is going to write back and say, no, that's a table, you get a little bit smarter. So we got into this argument over who owns that improvement to the system that resulted from those photos, right? And it wasn't clear. So now in our agreements, we're specifically saying that, you own the copyright in the work, but we control all results, all vectors, all derivations, all stuff, and that is exclusively ours.
So what is your advice to creators and writers who feel discouraged or they feel afraid that they will exert a lot of effort and spend a lot of time, and end of the way their work will be infringed in some or violated in some way or another? So how you can encourage them?
Well, I think human creativity will always be protected and will always be encouraged. I understand some creators feeling discouraged at the moment, but I do believe that this situation will evolve as we work through it, as the law works through it, to the benefit of the human creators at the end of the day. And that's what the law exists for. So have faith, I would say.
You know that talking about AI will not stop.
Yes.
We can continue talking for hours.
Yes.
My last question to you, how or when you can expect that we will have a clear cut or a clear image dealing with AI tools and IP rights and the clear cut laws, like in 5 years or 10 years and 20 years?
I have no way to say. I mean, that's a very difficult question.
Yeah.
I think we'll know a lot more in 5 years than we know today. I'm pretty sure we won't have an answer next year. So I would say, that we'll be pretty far up that curve in 5 years would be my absolute guess, with no substantiation.
I hope so. Mr. John Osha, it was my pleasure having you with me today. And we enjoyed your discussion and your talking and your insights too much. And inshallah, we'll meet in the future again. We'll have more time to talk about AI. Maybe next year, next month, we don't know. Thank you so much for accepting my invitation. It was my pleasure. And see you, inshallah, in the future. Thank you so much to follow up for today's episode, and see you in next episode, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.